Hi, this is Keena Kim with PivotalDiscovery.com. We're here at the Masters Conference with His Honor Judge Simon Brown QC and eDisclosure expert Chris Dale. Now they're going to share a little bit of their background in terms of how they met and share their thoughts on eDisclosure, costs versus U.S. sanctions, and proportionality. Thank you, gentlemen, for joining us.
Thank you, Keena. My name is Chris Dale. I am an English qualified lawyer who then became a developer of software for litigation. When I converted to the idea of talking about the subject, I was introduced to His Honor Judge Simon Brown QC at the Birmingham Civil Justice Centre. The message I was given was that he was a judge who was keen to encourage litigants into his court by making it an efficient place. And that was an attractive message to me, so I went to meet him. Since then, which was about 2.5 years ago, we've done a lot together using our respective interests and influences to try and encourage English courts and English lawyers, as well as English litigants, to make better use of the rules as they stand in the English court.
Yes, and since that time we've teamed up on a number of occasions. In particular, we've been able to organise ourselves to give talks to judges at the Judicial Studies Board, soon to be the Judicial College, where we've spoken in front of a whole host of judges, including some of the senior ones, about electronic disclosure, and using Chris's experience of practices around the world, particularly here in the US. And that has been absolutely invaluable in teaching judges how to deal with the big issue of electronic disclosure. And we've also been involved with practitioners, Chris, too, haven't we?
Indeed. One of the messages that we get back from practitioners in England is that the American experience, or their perception of the American experience, is off-putting. There's a perception that Americans make a big song and dance about it, that they run up a lot of unnecessary expense, and that they have an addiction to the letter of the rules as opposed to the objective to be obtained by the parties, the pursuit of justice. I know that to be wrong from my own knowledge, and part of my endeavour is to tease out those aspects of the American practice that are very similar to ours, and to use that as an example for the English courts and for English judges as to what is the best way of conducting things. We just sat through a lecture by Judge Facciola, one of the best-known experts on this side of the Atlantic, and much of what he was saying is very close to what our rules require and to what our judges ought, and in many cases are, doing.
I think that's an important point, because what Judge Facciola was stressing was that the recent, or relatively recent, changes of the rules in America mirror those which we have in England and Wales. And in particular, the role of the judge now as the case manager. And that's absolutely critical, because before the parties start actually messing around with their disclosure, and before they incur all those costs, the judge is going to have his say and give directions upon that, and how you go about it, how much you're going to spend, and the like.
Our Rule 1, very similar to your Rule 1, is called the overriding objective. And it overrides everything except express rules that point you in a particular direction. What is overriding is the pursuit of justice by, amongst other things, making the most efficient use of court resources, which is a factor which Judge Facciola was particularly attracted by, because there isn't an express equivalent of that in the American rules.
So what we have in our courts now is that when people come, certainly before me, for a case management conference, they know that they ought to have discussed electronic disclosure before they come. And if they haven't, they're likely to be sent away and pay the costs of that wasted time. So we're getting to grips with it, and the awareness now of practitioners coming to the court that they've got to address the issue of electronic disclosure is an important one, and we're now practicing what we've been preaching.
In terms of percentages, are you finding a number of what is the percentage of practitioners that come in unprepared versus those that are coming in prepared with regards to eDisclosure?
Well, it's less. Before, there was a relative ignorance about this, because the requirements are slightly buried away in our rules. They're in a practice direction under a note 2A, and therefore people say, well, we didn't really find that. So that was they wouldn't actually confess that, but that's really what they meant. But now they know it's there, and it's been drawn specifically to their attention, also by a draft form of the ruling that I'm going to give, or the directions I'm going to give at that case management conference. That draft is already on the web. We have a Mercantile Court's website, so that anybody, whatever level of practitioner, they will know that that is a requirement, and they'll have to address that when they come to us. That's the agenda.
That applies also, of course, to the judges hearing the case, because they have that same draft order in front of them. And they've got two options. They can either make a direction about it, or they can strike it out. And since it's a direct copy of a provision in the rules, it seems unlikely that many of them are going to just strike it out. One of the things we heard from Judge Faciola this morning, which was particularly interesting, was him negativing the idea that American judges in his position leap up every morning wondering who they can sanction. He made it absolutely clear that sanctions were a last resort, that there was a continuum from negligence through willfulness, through to ill intent, effectively. I forget exactly what expression he used, but
lack of good faith.
Lack of good faith, yes. Indeed. And that sanctions come only at that extreme, at the far extreme of that, and that one does not get sanctioned in his court anyway for mere negligence. We don't have the concept of sanctions in the English court. You can be punished in costs in a manner that's designed to reflect the loss caused to the other party by your failure to comply with the rules, or by some aspect of the way you ran your case, as well as whether you won or lost it. And Judge Brown had a case last week which illustrates that particularly well.
Yes, in that particular case, what happens with us is that the successful party will be entitled to their costs normally. But in exercising your discretion as to whether you're going to allow that to happen, or whether you're going to dock the costs, you can take into account conduct. And conduct includes whether or not people have actually performed their obligations under the rules on electronic disclosure, and that's what I did. I actually docked the costs by 50% because they didn't comply with the rules on electronic disclosure.
In amongst that judgment, Judge Brown gave a very good summary of the legal framework that leads to that, and emphasised in particular that it's not just a matter of punishment for non-compliance with the rules. That is important, but it's not what the overriding objective has in mind. The overriding objective has in mind how efficient is it to get justice in the courts. And it was that aspect of it that drove the conclusion, because effectively a whole day extra was taken in court dealing by the investigation of witnesses with things that could have been dealt with by simply reading documents if disclosure had been given properly.
Yeah, I think that's important, because we're not there, as Judge Faciola said, and one's very reluctant to start criticising lawyers just for the sake of being like a schoolmaster and criticising people for doing their prep badly. But we are there to provide an efficient court service, and if people are not working efficiently according to the rules, then they can't expect to have their full amount of costs. So that's how the message gets home.
Yes, and the message gets home is emphasised more, I think, by drawing out the fact that what happens in the American jurisdiction, which by anybody's estimate leads the world in the whole subject of electronic discovery, by drawing out the fact that there are at least as many parallels as differences between the way our respective systems work.
Yes, I agree with that.
Great. Thank you so much for joining us today, gentlemen.
Our pleasure.
Pleasure.